Okay. All right. Well, welcome everyone to our August 2023 webinar regarding, am I zoned Greenbelt? I think I got it wrong, Nicole. Anyway, I'm Lena Juarez. I'm the Executive Director of the Florida Agritourism Association, and the association is pleased to bring you this month's webinar. We have a very special guest today. Some of you may have met her at our first annual conference in July. Her name is Nicole Poot. She practices with the statewide law firm Lewis, Longman and Walker. She is based in the St. Pete office and specifically is in the agricultural practice area, focusing on environmental, local government, land use, administrative, civil, and appellate litigation law. So we particularly consider her a friend of the association because she knows so much about land use. And with many of you receiving your trim notices by the September 1st deadline, you'll know what to do with the property appraiser, or you'll learn more today about working with a property appraiser to address issues. Nicole is also very active with the St. Pete Bar Association, as well as the Florida Bar Association, and she is considered one to watch in the section of environmental law with the best lawyers of America. And I would consider that's true too. So Nicole, welcome today, and I'll pass it off to Sarah for some administrative notes for this webinar today, and then Nicole, take it away.
Hi, everyone. I'm Sarah Harris with the Agritourism Association. Just wanted to go through some housekeeping. If everyone can stay muted, that will help with background noise. And if you have any questions, go ahead and drop them in the chat box. I will address them as needed. So Nicole has divided her program into a couple different sections. So as one comes to an end, we'll look at the chats and see if there's any questions pertaining directly to what she's discussing. Otherwise, she'll have some time for a Q&A at the end. And if you have any questions, feel free to drop it in the chat. All right, Nicole.
Thank you both for such a warm welcome. So I'm going to hopefully share my screen. And you should be seeing first slide of my presentation. So what do you mean I'm not zoned Greenbelt? Today, I'm going to be talking to you about the difference between zoning and tax classifications and the role the property appraiser plays in the tax classification process and how it's important to agritourism and your agritourism operation. And then in the event that the property appraiser denies an ag exemption, how you go about challenging that denial. So really we'll start off with some information about land use planning generally, tax assessment generally. We'll go into information about the property appraiser, what they look at when determining whether or not your property can be classified as agricultural from a tax assessment perspective, and then how to challenge a denial notification from the property appraiser. So we have two general mechanisms of classifying land. So there's different ways of classifying land, and you do this for different purposes. And interestingly enough, they are governed by various areas of the law, and they're governed by different areas of the law, even though when you look at various land use statutes and various tax assessment statutes, they kind of interplay with one another and they make references to one another, and really it's a big mess. But they are very two distinct ways of classifying land, and they're regulated differently. And the people in charge of regulating them, administering the programs, et cetera, are different. So in the tax assessment field, the property appraiser, who is an elected county officer, and all of the counties have their own property appraiser, as established by the Florida Constitution, have a duty to determine the value of all property within the county, including improved and vacant real property, tangible personal property, and agricultural property. So the property appraiser determines whether or not your property can be classified as ag for tax purposes. On the other hand, you also have land planning regulations. And generally speaking, your local government, whether that's the city or the county, depending on where your property is located, governs land planning. And you have layers of land planning, and the overlay layer of it all is your comprehensive plan, your local government's comprehensive plan. And the comprehensive plan guides future growth and community development. And it contains elements that address future land uses, housing, transportation, infrastructure, coastal management, conservation, recreation, open space, capital improvements, and intergovernmental coordination. So really what the comprehensive plan does is it acts as a blueprint for your community. One of the important elements of the comp plan is the future land use map, which projects future land uses. And land uses is an important concept when we're getting into zoning. And really what zoning does, and your zoning ordinances, your zoning regulations, they turn the comprehensive plan into a reality. And that, becomes important with respect to when you purchase property and looking at and evaluating how it's zoned. So the importance of zoning, why do we care? Well, zoning dictates various land use activities by classification for the purposes of planning and safety. And there's many different kinds of zoning categories unique to municipalities and counties, depending on, the historic area, whether you're a coastal community, whether you're more inland. But there are some general categories that you see time and time again. And that, of course, is you've got your residential use areas, you've got your commercial, industrial, agricultural, recreational, and historic use areas. And in those higher or overlay zoning areas, you also have subcategories, and those subcategories may provide more detailed specifics on how the land can and cannot be used. So in some jurisdictions, maybe you have the main zoning is residential, but residential might also allow for certain commercial, industrial, or even agricultural uses. So just because the big zoning category is one, it might include other zoning categories. And oftentimes you'll see in the zoning code complete prohibition. So maybe you have an agricultural zoning area that completely prohibits any industrial type activities. So what is agricultural zoning? So agricultural zoning or ag zoning refers to designations made by a local jurisdiction that are intended to protect farmland and farming activities from incompatible non-farm uses. So you might have a situation, you might have an area, jurisdiction that, it's completely incompatible to have ag and to have a residential development. And so maybe in the zoning code, it prohibits, residential development, or it prohibits certain types of development in the ag zoning area that the local government has determined to be incompatible. So typically you see ag zoning designated as A1, and the purpose of the zoning is to conserve and protect open land uses, foster orderly growth in rural areas, and prevent urban agricultural land use conflicts. So the neighbor to neighbor conflicts that you see, issues that come up on from both, if you're a farmer and also if you're a neighbor. So these things are worthwhile considering, especially when you're purchasing property and you want to use it in a certain way in the future. So on the flip side, then, we've talked about zoning and we've talked about agricultural zoning. Now we have something which is the agricultural classification, and it's colloquially known as, the Greenbelt law. And it's housed in section 193.461 of the Florida statutes. And really what it does is Florida law provides preferential property tax assessment for farms and farm operations that are classified as agricultural. So in general, the Florida Constitution requires that all property in Florida be assessed at its just valuation. And so that is the fair market value of the property. And in general terms, that fair market value is based on the highest and best use of that property. And that simply means that the value of the land and its most valuable potential use, for example, the highest and best value of a piece of undeveloped land could be its value after it has been developed into condos or a subdivision. But what the Greenbelt law does is really it acts as an exception to this highest and best use tax valuation because of the value of agricultural land. And what it allows for is land to be classified as agricultural to be assessed at a lower tax rate than if the property were not being used for agricultural purposes. So the Greenbelt law is different than your zoning category. So you theoretically could be zoned agricultural. You could have a piece of property, parcels of land on land that is zoned agricultural. But if you're not classified that way, and you don't have that Greenbelt tax classification, you're not going to be assessed as if the property were being used for agricultural purposes. And it's very easy to get the two, to conflate the two, because you're in both contexts, you're talking about zoning classifications, tax classifications. It's confusing, and it's a distinction that is important to remember and to understand the differences between. So pursuant to section 193.461 3A, no land shall be classified as agricultural land unless an application is filed on or before March 1st of each year. So what does that mean? Well, you have to reach out to your property appraiser before March 1st of each year and seek agricultural classification from them. And only lands which are used primarily for bona fide agricultural purposes shall be classified as agricultural. And then we have this definition: bona fide agricultural purposes means good faith commercial use of the land. And the property appraiser is the party in charge of determining whether or not you have a good faith commercial agricultural use of the land as of January 1 of each year. And if you're using your property in that way, then the property appraiser will grant you your agricultural classification. Your class is ag, your taxes will likely be lower, and that's how that works. As I mentioned, there is a distinction between agricultural zoning versus this agricultural classification. And as I mentioned, zoned for agriculture does not receive an automatic agricultural classification from the property appraiser. One, you have to seek the classification. Two, you have to establish with the property appraiser that you meet the parameters of bona fide ag. So zoning and ag classification for taxation, they're not one and the same. And there is no guarantee that land will receive an agricultural classification for taxation regardless of its zoning. So just because you're zoned ag you can't go into the property appraiser and say, hey, I'm zoned ag, give me this classification. They do their own independent evaluation based on evidence that you submit. Now, some jurisdictions I've seen, they might do an inspection, so you don't need to submit every year, but you have to be really mindful of what the property appraiser requires if you have a property that remains in your ownership that you're renewing the classification on annually, because that's the other thing that they make note of in the statutes and also in various property appraisers' websites, is that a change in ownership, you have to reestablish that the use is still bona fide ag. There's also various things you can submit if you're leasing your property to someone for bona fide ag purposes. You can submit the lease, and then the burden is on you as the property owner to ensure that the folks that are leasing the property are actually, engaged in bona fide ag. So as I mentioned, January 1st is the statutory assessment date. And what that means is that the property must be in use for its bona fide agricultural purposes on or before this date, or a reasonable effort has been made to place the property in this use. That reasonable effort parameter, again, you provide evidence to the property appraiser that that's taken place. And the filing deadline for the agricultural classification is between January 1 and March 1st of each and every year. Do we have any questions?
I don't see any. Is it possible to receive agricultural classification on a property zoned other than ag?
That's a good question. Theoretically, maybe. As a lawyer, we love I think it depends. I did a little bit of research into this recently because I think it's a good question. And I think the answer to the question, looking back into the zoning code of wherever your property is located and determining whether or not ag is a permissible use. So maybe let's just say it's a residential, let's say the zoning classification is residential. But in the zoning code, it says that, you know, so much property, an ancillary use could be ag. Then I would say, yeah, maybe, if you can meet all the criteria that the property appraiser looks at to establish that it's bona fide ag, and you're also meeting the zoning code in that, you know, ag is a permissible use. You know, it's going to be fact specific, and but so as us lawyers like to say, it depends, but maybe. What else do we have? Oh, my goodness.
Pam mentioned to Zach that her land is zoned RM6, but we have an ag exemption.
Sure. So that's so the way Pam has it, it's a similar situation. I'm sure RM is maybe a residential type zoning district that allows ag. So the property appraiser would come in and establish. The property appraiser is not looking at the zoning. The property appraiser is looking at whether or not you've got a bona fide ag use. And we'll talk about the criteria that they evaluate in making that determination shortly.
And can ag classification or exemption be retroactive?
Generally, if you miss that March date, no, because it's as of January 1 of that assessment year. So if I understand the question correctly, you either have to prove that it was in use on that date, or that you were taking all the necessary steps to put the property in use as of that date. So, and it also, it doesn't give you a retroactive effect. Like, let's say last year it was being used that way. I don't know that you could then, you know, try and get like a tax refund or something in that capacity. I don't believe that it works like that.
And can retail be denied under agritourism?
Can retail be denied under agritourism? I'm sorry, Simon, I don't understand the question.
Simon, if you want to unmute yourself and verbalize it, that might be easier. Okay, we can come back to Simon.
Come back to that. Alrighty, so moving along. No. Come on, computer. Okay, here we go. So why does Greenbelt classification matter to agritourism? And I have on the screen a couple of important laws related to agritourism. The first being, you know, the Right to Farm Act, which is a law that protects farmers from, in a very broad sense, is a law that protects farmers from, you know, nuisance claims and other such similar actions. And in the Right to Farm Act, there is a provision, and it's subsection 6, and it's called the Limitation on Duplication of Government Regulation. And it specifically references land classified as agricultural land pursuant to section 193.461 of the Florida statutes. And it limits a local government's ability to adopt an ordinance, regulation, rule, or policy to prohibit, restrict, regulate, or otherwise limit an activity of a bona fide farm operation on land classified as agricultural. So similarly, the agritourism statutes contain a provision that limit the amount of regulation that a local government can enforce over agritourism on land classified as agricultural. So that distinction between zoned land and classified land, if you're classified and you have the Greenbelt classification, all throughout the statutes, and these are just two big examples, but there's lots of places in the statutes where classified ag land has more protections than if you're just in a zoning district that allows for agriculture, and you're not classified, and you're not using your property for the bona fide ag use. So it is important to agritourism because of the protections that it affords you as an agritourism operator, and as an ag operator, to have your land classified as agricultural by the property appraiser. So how does the property appraiser determine eligibility? So really, what is bona fide agricultural purposes? That term is broad, potentially. It's not clear. And so the statutes and both the statutes and the property appraiser's offices, but basically this is derived straight from the statutes. They determine whether or not the land is used for commercial agricultural purposes by looking at the following 7 factors. So one of the factors that they look at is the length of time the land has been used for agriculture. I'm sure with a favor towards if the land has been used that way for years and years on end, it's more likely to be commercial bona fide ag. Whether or not the use has been continuous, the purchase price paid, the size as it relates to specific agricultural use, so that there's no limit, there's no requirement that the property be X amount of acres or Y amount of acres. But if you're saying that you're using 0.1 of an acre for forestry or something like to that effect, the property appraiser is going to look at that and say, well, that's not enough. That's not enough land to support that agricultural use. The other thing that they are going to look at is whether there has been an effort to care sufficiently and adequately for the land as it pertains to the agricultural endeavor. This includes, but is not limited to, fertilizing, tilling, mowing, reforesting, and other accepted agricultural practices. So they will look at what type of use you're stating that your property, or that the property is being used for, and they can look into whether or not you're taking the measures necessary to support, are you taking the measures necessary to support your cattle ranch or your blueberry patch. And an apiary, and with respect to size, like an apiary is going to require less space per se than if you were than potentially a cattle farm. The other thing that they will evaluate is if the land is leased, the length and terms and conditions of the lease. And so with all of these factors, you establish it by submitting evidence to the property appraiser. Maybe you have them out on your property, maybe, it's usually not the property appraiser specifically, but somebody from their office. And this falls into also the catch-all, because there may be factors from time to time that become applicable that you can use to establish that you have a bona fide agricultural purpose and a good faith commercial agricultural use of the land. Do we have any more questions?
I don't see any more right now.
Alrighty. So something else, I don't know why it won't change. Oh, here we go. Okay, so something else to consider as well, because we are in agritourism, is section 570.87 of the Florida statutes. And this statute deals with agritourism's participation and impact on the land classification. So as we talked about in the last slide, the property appraiser evaluates certain criteria to determine whether or not there's a bona fide use of the land. Something of note, because the legislature has been very clear that we are to promote agritourism. Agritourism, goes hand in hand with traditional agriculture. A classification may not be denied or revoked solely due to the conduct of an agritourism activity on a bona fide farm, or the construction, alteration, or maintenance of a non-residential farm building, structure, or facility on a bona fide farm that is used to conduct agritourism activities. So in the event that you use your storage facility, your cow barn for agritourism, in addition to using it for your traditional agriculture, the property appraiser can't deny the classification for that reason. And what they look into for this, so long as the building, structure, or facility is an integral part of the agricultural operation. Now, what that means per se has not been determined by a court yet, but to the extent that your cattle barn, your non-residential farm buildings are an integral part of your traditional agricultural operation, it shouldn't matter whether or not they're used for agritourism. That shouldn't affect your classification. But there is a caveat to that in how it's assessed and valued. So these improvements must be assessed at their just value and added to the agriculturally assessed value of the land. So they're not subject to the same tax break that just purely, the pure ag farmland would be. Oh, and I see a number of questions now.
Yeah, so Pam is asking, what evidence do you suggest to submit to the property appraiser? Photos, site maps, receipts, taxes?
I would say everything. All of that stuff is good. Pictures worth 1,000 words. Pictures, video, offering, them to come out and see your operation. Tax documents are helpful at times as well. Any kind of document that supports your traditional ag operation could be submitted and help. And in the context of this statute, when you're dealing with the non-residential farm building that is also used for traditional ag and also for agritourism, to the extent folks, you know, maybe the building gets used as a break room. If you keep, you know, if you're using it as a farm office, you know, anything that can show, any document that can support that should be included when you're seeking your classification.
And we had one other, Mitchell asked if you could discuss animal useful to man case. I'm not familiar with that. I've asked for clarification.
I'm sorry, Mitchell, I'm not familiar with that, but happy to discuss it, look into it.
A bird case?
I'm sorry, that's not.
Yeah.
It's not enough. I need more vowels, Vanna.
Okay. You can go on and we can come back to him. Oh, sure.
So we've talked about the difference between zoning and classification. We've talked about what the property appraiser looks at by way of things that you can submit and how they evaluate whether or not you have a bona fide farming operation, bona fide ag. You go through the process, you submit for classification, you submit all your evidence, and you get a denial. What do you do? Well, there's really three steps you can take if the property appraiser denies your classification request. You can request a conference with the property appraiser, and this is an informal meeting with them. They'll have their staff, they'll be there, and you can discuss with them, you know, to the extent, you know, you provided them evidence, you know, why was it denied? You know, is it just a matter of trying to get more evidence? Did you forget to submit any evidence? And so it's just one of those types of denials. But something that's very important to remember is that a conference, requesting a conference with an informal conference with the property appraiser, does not change the statutory deadlines that are set forth in Florida law. So to the extent you don't get the relief you want from a conference with the property appraiser, if you don't go to the next option, which would be an appeal to the Value Adjustment Board within the requisite time frame, that could be problematic. So the next step you could take is you can appeal to the Value Adjustment Board, and we'll talk a little bit about who the Value Adjustment Board is and what their role is shortly. The property appraiser, pursuant to Florida statute, is required to notify property owners by letter of a denial of their classification. And then you have 30 days from the date of that denial to file a petition to the Value Adjustment Board to appeal that denial. If you don't want to go down that route, there is also an avenue to just go to circuit court. So instead of going through an administrative proceeding, which is what an appeal to the Value Adjustment Board would be, you can go straight to circuit court. You can also go to circuit court if you go through the Value Adjustment Board and you don't like, if they deny it and you're not satisfied with that result, you can take it before a judge. And something that's important to note is that review by the circuit court is de novo, and that simply means that it's as if, you know, the judge gets to look at all of the evidence themselves and evaluate it for themselves. So if you've gone through the Value Adjustment Board process, when you go to circuit court, you'll go through all of the same evidence. and anything additional you can find. And of course, if there's also the ability to request the conference and also go through one of the other mechanisms. So to the extent that you know, you want that informal meeting, in addition to these other options, it doesn't hurt to request the conference and then also file a petition to the Value Adjustment Board, or of course a circuit, the relevant and jurisdictional, correct jurisdictional circuit court.
So Nicole,
Yes.
I just sent you a link to the case that he was referring to. It's McClendon. And the question, I will raise wild birds for sale as pets on my property. Can I qualify for an agricultural tax exemption?
Oh my goodness. Interesting hypothetical. And what the case is saying, it looks like, and of course, without having read the case, I have not seen this case. Wonder if it's how new it is. I think if looking at the parameters, if you can establish with the property appraiser that you've got a commercial ag operation, then yeah, maybe it's possible to have it classified that way. I'm not sure. I think it's going to depend. Well, a lot of this is dependent on the interpretation of the law by the property appraiser, and it is I have seen it be inconsistent between jurisdictions. Just, we'll say that. So the Value Adjustment Board, who is the Value Adjustment Board? So each county has a Value Adjustment Board. They're a 5-member board, and they have 2 members from the county commission, 1 from the school board, and 2 citizens that you're appealing to. So that's important to note. At times, you know, who is evaluating this? These folks, you know, is your county a county that has a lot of ag? Because that can be helpful to explain your operation, you know, what your bona fide ag use is. And that can assist understanding who is specifically on the Value Adjustment Board, can help you in making a determination whether or not you want to proceed with a petition to them, or if you want to go to circuit court. So the proceeding in front of the Value Adjustment Board is quasi-judicial in nature. It consists of presenting evidence, and the statutes have very specific, and I don't want to get into the details, but they have very specific requirements by way of when evidence needs to be provided to the other side, what, you know, all of that looks like. But of note, when you seek to go before the VAB, there is a petition application that has to be submitted in a substantially similar form. I always recommend that you look at your specific property appraiser's website and use the form that they have available to make the request. Within that, 30-day time frame. Once you go before the VAB, you have 20 days from the last day it was in session is when they issue their final decisions. And as I mentioned before, if you are disappointed or you want to seek a different decision, you can certainly go to circuit court and challenge a decision of the Value Adjustment Board in that capacity. And that, of course, it looks like your traditional lawsuit. You filed a complaint and you move forward. That way. There's also requirements to keep in mind that to the extent that you go to circuit court, a good faith effort has to be made to pay the taxes on the property. So that's maybe a pitfall. If you say, oh well, I'm in this challenge and I don't pay the taxes, that can cause issues for your circuit court action.
While we're on the slide, can members from the county commission and school board be staff, or must they be elected?
So they're elected to the VAB. So the VAB is the VA. Well, are they elected or are they appointed? Generally speaking, the VAB. But I think the question is going to the Value Adjustment Board is either appointed or elected by.
I think she's asking if the members. So for two from the county commission, do they have to be elected members of the county commission or staff?
Oh, yes. They have to be elected members of the county commission. They're not generally staff personnel.
So the county school board would be elected county school board members.
Yes, absolutely. And then they elect or appoint 2 citizen members as well. So of course, if you get county commissioners that are favorable to agritourism, that's helpful. And also, there's a education component as well, and you can always speak to your county commission to the extent you need to on these matters. So with that, I did leave time for more questions at the end. I wanted to give you all time to ask questions. So are there any other questions or anything else you want me to chat with you about? I'm happy to answer questions or chat about anything we talked about this afternoon.
Is it okay if I ask my question verbally?
Yes.
Thank you. That was a great presentation. I really appreciate it. I have a business that's essentially a 2-acre botanical garden. It started 40 years ago, and it initially was only selling plants, growing and selling plants, but it's transitioned over time, and we had a Greenbelt, and at some point it slipped away. And now our core business is we make and sell wrought iron work in the garden. So it's a 2-acre garden where people come and walk around. It's like a botanical garden and they enjoy it. Sometimes they buy things, sometimes they don't. We do sell some plants, but again, our core business now is selling metalwork. And I didn't know if it's worth exploring. Like, we've had different people that have asked if they can have their bees there and, to pollinate our flowers. And essentially my question is should I be thinking about a way to get the Greenbelt back? Is it feasible given that we have this botanical garden of probably thousands of different plant varieties, but arguably agriculture is a very small part of our business? Does that make sense?
It does. And I should note for everybody, I can't give you legal advice. So as a lay person, in that case, it may be possible / it may be you know, depending on how you want to continue using the property, it might be, you know, to the extent that you can establish, looking at the criteria that the property appraiser looks at, these criteria on this slide.
Yep.
If you can meet that criteria, it might be worthwhile. It might be worth investigating, but it really needs to be a bona fide agricultural purpose, which equates under the definitions to commercial agricultural use of the land. So to the extent that, you know, if you allow like if an apiary to come and use the property, maybe that would, you know, help you meet these criteria. But it's going to be fact specific, you know, looking at all of the different parameters and criteria that the property appraiser would look into to make that determination. And frankly, how you want to use the property. If you already have, you know, if you can go through, if you're not, you know, violating any of the zoning codes, and you can go through the building department and get what you need approved, you know.
Yeah, it's zoned agriculture. I mean, there's a residence there that's been there since 1945, but it is zoned agriculture. And my core goal is less about the tax benefits, although those are great. It's more about, we were going to start having events, and my understanding is agritourism would potentially reduce the probability of frivolous lawsuits.
Sure.
So just in that context, would you be thinking about it differently? And I understand you can't give legal advice, but just broadly.
Broadly, I would see if you can meet these criteria, and the thing is it doesn't hurt to, I mean, I don't see any harm in seeking the classification, especially if your ultimate goal is to have, you know, agritourism events on the property that, you know, marry together, you know, what sounds like a nursery type operation, and, you know, maybe the bees, etc. Yeah, it would be worthwhile from that perspective. I think.
Nicole,
great. I really appreciate it.
A couple other questions have come in. Do you have to apply every year before March 1st for tax exemption?
You do. Now, different counties, different property appraisers have different, some of them, if you look on their websites, they might have a specific renewal process that doesn't require as much backup evidence as if it would in the first time. But yes, you are required to apply every year before March 1st, or go through whatever the renewal process is, because as I mentioned in the presentation, it's assessed every year as of on or before January 1st.
Okay, thank you. Simon breeds sheep and he raises plants and would like to start a brewery. Is this possible? I would presume you have your ag classification, Simon?
Yes.
Okay.
So that's an interesting question. A brewery would have to fall under agritourism as a definition, and the I guess where you have the brewery would have to be integral to the agricultural operation. So on something like that, that would be fact specific, and as I mentioned previously, I can't give legal advice, but in a broad sense, to the extent that you have your ag classification, and to the extent the brewery falls under the agritourism definition, that's what you'd have to evaluate.
So Woody has ag classification, but not Greenbelt. If my local government challenges my agritourism activities, will a Greenbelt classification help me with my local government?
It will. It will. It makes it, having the Greenbelt classification helps significantly from local government, one, new regulations, and also other enforcement of their existing regulations.
Okay, and yeah, so Katie, you're protected with your ag classification, which gives you protection under the right to farm Greenbelt. Local government property appraiser cannot deny you your ag exemption due to agritourism activity.
Yes, exactly.
Yeah. Okay, we're winding up the hour. Any other questions out there for Nicole?
Oh, there's one more. When you go to the VAB, is it common to represent yourself or to bring an attorney? So as an attorney, the process, I'm not sure. I of course, when I go to the VAB, it's on behalf of a client. So yes, they bring their attorney. I don't know what the everyday practice is, but the property appraiser has an attorney. And I will say that going before the VAB, there's, especially if it's contentious, an attorney can help navigate the process, navigate the evidentiary requirements, and present your case from a from a less emotional stance potentially. So I always, bringing your attorney wouldn't hurt, but you can represent yourself, of course.
Okay, going back to make sure I didn't miss anyone because I missed Pam. I don't see anything. I did send Nicole the link about the bird case, Mitchell. So
yeah, I'm happy to look at that. I had not seen that one before. It's interesting because to the extent an aviary or whatever that fits, if that fits under ag, then maybe that it's I'm interested to look at that case.
So Nicole, would you also put your contact information if you have one more slide? We put it in the chat for those that would want to contact you after this webinar. But then we have a member that would like to share some information about Miami. So Katie, do you want to go ahead and do that?
Yes, can everybody hear me?
oh, hello.
Yes.
So it's not Katie, it's her husband, Matt.
Hey, Matt.
Oh, okay, sorry, Matt. I'm just looking at the
That's okay.
the screen.
Katie's coming back from Orlando from the Nursery Growers Association.
Oh yeah.
show. Anyway, so I spoke with Frank Gonzalez in with MAFA, which is the Miami Agritourism Farms Association, and they're a group of almost 40 operators, and 7 of them have had their AG classifications removed for the participating in agritourism activities, which is a clear violation of the statute. So they're in a big fight about this right now, and they're also making the operators in the Redlands get special use permits for agritourism, which is also clearly not needed under the legislature. So I just wanted to put that on the radar. They collected quite the war chest of funds for a lawsuit, and it will come, I expect, in the next 3 to 4 weeks for things to really get heated up down there. Just wanted to get that on everybody's radar, that we need to keep watch of what happens with their local government and the enforcement, which is clearly outside the 4 corners of the law down in Miami with the MAFA members.
Yes, Matt, I really appreciate you bringing this to the group's attention. We have been following it. We've heard from some of our members down there, and there is several committees within the commission, and I'm looking for the date right now. I want to say it's September 9th or 10th. They're considering 2 ordinances, and one of them deals with the agritourism. They want to modify a current agritourism ordinance. And so, yes, we are definitely following that. We're definitely concerned. So thank you for sharing that. And I see, Sarah, there was another question. Yes, this webinar will be shared. It has been recorded and you can watch it later again or share it with others. Nicole, do you have some final things you'd like to share with the group?
No, I don't, but thank you all so much for spending the afternoon with me. I really appreciate the questions, and I really appreciate being here. Agritourism is a topic that's near and dear to me, and it's been a fun addition to my practice area. So it's really great to be here today.
Well, we really appreciate you. We thought you did a great job at the conference, which is why we wanted to have this follow-up webinar with you as our host, as our guest. And to everyone on the webinar, our association is always looking for new topics for our members of various webinar topics. And one we're considering is seasonal employment. We're talking to several potential speakers for the fall webinars, but if you have any ideas, please feel free to reach out, make recommendations for topics and or speakers. So with that, I want to thank Nicole again. Thank everyone for being on this webinar. And if there aren't any further comments, everyone have a great evening, and thank you again for participating.
Thank you.
Thank you.
Yes, thank you, everyone. And keep an eye out for emails, because that's how I try to notify everyone of upcoming webinars. Have a good afternoon.